Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video episode of Business is More Exciting Than Any Game. This is a podcast where I talk about business issues of interest to health professionals. And today I want to talk about trademarks. And in particular, I want to talk about why, if you are a doctor, a dentist, a nurse practitioner, or some other healthcare provider operating and running a small practice that hopes to grow into a big practice one day, why you may want to consider getting a registered trademark, a federally registered trademark for your practice, your business of healthcare. First of all, what is a trademark? A trademark is essentially a word, a design, a logo, a combination of a logo or a design and words that identifies the source of goods or services, and allows consumers to tell who is the provider or what's the business that is actually selling them specific goods and services. For example, giving an example outside the healthcare area, when you drive down the street and you see the big golden arches, you know that is a McDonald's, and you know that if you go in there, you're going to find all the normal things that you expect to find on a McDonald's menu. So you know what the source of goods and services are strictly from seeing those big golden arches as you drive down the street. Similarly, if you go to the shoe store and you see a box with a big swoosh on it that looks like a check mark, you know that product is made by Nike. And so Nike is the source of those particular shoes, those goods. And in your mind, you know that it differentiates those goods, those shoes, from shoes made by another company, like Adidas or Puma or some other shoe company. Now, when you run a small business, including a healthcare business or a healthcare practice, you want consumers, your patients or your prospective patients, to know what is the source of the services that you're providing. You want to differentiate yourself from your competitors in the healthcare field. So take another example. If you look on the website for the U.S. Patent and Trademark Office, the uspto.gov, you can check trademarks, and you can look on there and see that the Mayo Clinic has a large number of trademarks. Same with the Cleveland Clinic. A lot of healthcare companies, particularly ones that operate on a national level, have federally registered trademarks. A federally registered trademark provides you with the right to use that name with respect to the goods or services that you're providing across the whole country. It allows you to, if someone infringes your trademark, to sue them in federal court. It puts the world on notice when you have a federally registered trademark that you are the owner of that trademark. You get to use the little R in a circle beside your trademark when you have a federally registered trademark. It's just a great thing to have when you operate any kind of business, and even in the healthcare field and in a healthcare practice. If you're going to be hoping to provide services to people maybe on a more regional or national level, it's something that you should consider doing, is seeking a federally registered trademark. Now, in particular, as healthcare moves across state lines with, for example, the Interstate Medical Licensure Compact, which allows physicians, if they comply with the rules and regulations under that law, to practice across state lines, to actually get licensed to practice telemedicine or tele-health across state lines. If you're considering doing that, and that, as healthcare evolves, that is something that more and more physicians may be doing. If you're going to be doing something like that, then rather than having just a simple single location medical practice in your particular state, you may be practicing in a number of states through telemedicine or telehealth under the Interstate Medical Licensure Compact. And if that's the case, you certainly don't want to have another provider, another physician or a medical practice operating under the same name that you're using, because that's going to cause confusion, and you want to differentiate your services, what you're doing, from your potential competitors. So just the fact that telemedicine is out there, telehealth is out there and is growing in popularity is one reason why you might want to consider seeking a federally registered trademark. Obviously, if you're going to be trying to expand your practice to be more of a national or regional practice, you would certainly want to protect your name. This happens a lot with respect to aesthetic practices, maybe dermatological practices, where they may have a lot of patients coming in from all over the country to get their services. If again, going back to my example, if you go back to the uspto.gov website and search on trademarks, you'll find that the television show that features a female dermatologist in that television show called Dr. Pimple Popper. Dr. Pimple Popper has a couple of federally registered trademarks. I think one of them may be for certain skin creams that are sold under that name, Dr. Pimple Popper. So if you're thinking ahead, thinking in a forward way, you may want to protect the name of your practice through a federally registered trademark. What are the types of trademarks that are out there? In other words, what is the spectrum of words or phrases that may be possible trademarks? Well, they run on a spectrum or on a scale from the least protectable to the most protectable as far as trademarkability. The least protectable is a generic trademark. And essentially, a generic trademark is not trademarkable. It's not protectable. You can't get a registered trademark for a generic word or phrase describing your business. For example, if you had a practice that just said doctor's office or medical practice, you're not going to be able to trademark that. It's generic. You wouldn't want to anyway, but that just shows you the scale. That's on a scale of 1 to 5. That's a 1, not trademarkable. Next up the line is a trademark that is considered descriptive. Descriptive trademarks might be something like Nashville Medical Office or West Tennessee Medical Office. That is slightly more descriptive than just a generic medical office. But again, that's probably not going to be trademarkable in almost all cases. The only way that descriptive trademarks get to the point where they can be trademarkable is if that trademark acquires a secondary distinctive meaning. People know what that is when they hear the name West Tennessee Medical Office. That's just an example. But again, that's if you have just a merely descriptive trademark, again, you're probably not going to be able to get that trademark registered. Next up the line is you have generic, you have descriptive. The next is suggestive. This is where the name suggests a trait or characteristic of the owner of the trademark. For example, speediest home delivery, speediest pizza delivery. Speediest is a word that gives a suggestion as to a characteristic of the applicant, of the person seeking to, or the company seeking to get the trademark. You're starting to get to the point where you may be able to get a trademark for that. So you have generic, descriptive, suggestive, and the last two are where you really want to be when you seek trademark protection. The fourth level is what is called fanciful. I'm sorry, the fourth one is arbitrary. Arbitrary would be something that is a word, a real word, that has really nothing to do with the company that owns the trademark. For example, great example is Apple for the computer company. Apple has nothing really to do with computers. So it's arbitrary. Arbitrary trademarks are very trademarkable. That's a great place to be if you have a arbitrary word word or logo in your trademark. That's something that you should be able to get trademark protection for. And the strongest trademark that you could have is one that is fanciful, which basically means that the trademark itself is a made-up word. It didn't exist before someone made it up and then sought to have it trademarked. Google is one. Xerox is one. There are a number of fanciful trademarks. Those are the absolute best, but you should be great with an arbitrary trademark as well. So if you're a physician or a dentist or a nurse practitioner or some other healthcare provider that is seeking to get trademark protection for the name of your practice, you want to try to get a name that you like that's more in the arbitrary or fanciful category. You file your application for trademark protection with the USPTO, you pay a filing fee, and the trademark examiner will look to see if it conflicts with another trademark that has either been registered or an application has been filed for, because they want to make sure there's not going to be any likelihood of confusion with another applicant or company that has a registration. If there is none, you'll get notice to that effect. The USPTO will publish the name of your proposed federally registered trademark in what's called the Official Gazette to see if anyone opposes it. If no one opposes it, then your trademark will proceed to registration. You'll get your registered trademark. The process typically takes several months, but it's worth doing if you think that you may want to practice more on a regional or national basis, or that you're going to perhaps have some potential confusion with other competitors in other states because of the nature of your practice. It's not terribly expensive. It's not terribly cumbersome to seek federal trademark protection, and so you'll see more and more healthcare professionals going to the extent of actually filing for and seeking and obtaining federal trademark protection for the names of their businesses, their offices, their practices. I hope this helps. If you have any questions, please let me know, and until next time, we'll see you. Thanks.